All right, we'll take care of that when we get the order. Now, back to the case that has been waiting patiently. We thank you for that. Resicap Georgia owner versus, nope, that's not it.
Sylvia Simmons versus
Sylvia
Willie
Simmons,
Williams.
yes, versus Willie Williams. Ms. Simmons is represented by attorney Sean Connor. Mr. Williams is present with the individual who I assume is the all other occupants of the home. It is my understanding that this was a transfer from magistrate court. There is a counterclaim. The rent past due requested up until February 5th was $3,960 plus attorneys. The answer requested dismissal of the case and a $100,000 counterclaim. All right. So, Mr. Connor, since your client has the primary claim, let's go ahead and hear from you, and then I'll hear from Mr. Williams on the answer to the primary claim and the counterclaim.
Yes, Your Honor. I just have a real brief opening statement and kind of provide some background information. Plaintiff is a defendant landlord. There is no written lease agreement executed by both parties. Accordingly, this is a month-to-month lease, but no set termination date. You're probably likely to hear about a option contract. The evidence will show that no consideration was paid by the defendant to secure that option. The plaintiff notified the defendant of her intent to initiate this action on April 10th, 2023, and receipt of such notice was acknowledged by the defendant in the answer he filed with this honorable court. The plaintiff initiated I'm sorry?
For a month to month, was it a 60-day notice to quit?
Yes, Your Honor, I was about to address that, Your Honor. This action was initiated on June 21st, 2023, which is more than 60 days after the notice was filed. The defendant was served on August 7th, 2023, and he filed his answer on August 9th. The plaintiff has not accepted any rental payments from the defendant since she notified the defendant that she would be terminating the lease. And the evidence will show that by and through the defendant's conduct, he has breached the terms of the lease and has acted in bad faith as it relates to the contract. Even if the option contract was valid, he has had nearly a decade to purchase a property, but he has made no effort or good faith try to even attempt to purchase the property.
Okay.
All right.
All right. Go ahead and tell me what the rental amount is per month, how many months we're in default. Please include late fees and any other additional penalties.
Okay. So the late fees, the monthly arrearages would be that $369. The monthly rent payment was $360. And again, we're not really seeking late fees. We just want to get the past due rent and possession of premises, Your Honor. I did not run those calculations. And we are asking for attorney's fees in the amount of $3,000. That includes the time spent here today and going to the magistrate court hearings and preparing all the filings and all that, Your Honor.
Okay, so it was $360 a month rent?
Yes, Your Honor.
Why so below the market?
This is a mobile home. It was in keeping with kind of the standard prices, at least as I understood it by my client, Your
Honor. Okay. All right. And when did they go into default for failure to pay?
Okay, so this was actually due to in the previous case that was involved that was started back in 2022. That was dismissed because my client continued to accept rent from the defendant after she had filed this action. This essentially is a retry of that where she has not accepted any payments from the defendant, even though you will hear evidence probably that he tried to make 3 payments. She promptly returned all those funds and retained no benefit thereof.
Okay, so let me be clear. This was a month to month. She gave him 60 days notice. Did the notice say you have 60 days to leave the premises? Okay. And she has accepted no money since the notice went out April 10th of 2023. And this action was filed on June 21st of 2023. Is that correct?
Yes, Your Honor.
All righty. And you're seeking attorney's fees per 13-1-11?
No, we were seeking under 915-14 for the purposes of delay and basically for being substantially groundless. There is no evidence to support an award of $100,000 to the defendant. He would possess the premise. He occupied the premises for the past 8 years. And essentially, as I understand, the defendant is claiming that he should be entitled to all the funds that he has paid for the monthly lease, and then some on top of
That
it.
would cover about 10 years of rent on a mobile home. Okay. All right. So my understanding is, what is the total amount in arrearage? Because you told me the monthly amount, but what is the total amount in arrearage that you're seeking?
We are only seeking that $3,960. Again, the issue here was not really the payment of rent per se. There
Right.
was some
It was
late
holding
payment.
over.
Yeah, essentially, yes, Your Honor. He is holding over. There's numerous other issues where there's some damage to the premises. He refused access to allow my client to inspect the premises, and just associated concerns, but the breach is not related to payment, Your Honor.
All right. And was there ever a written lease?
No, Your Honor. There's 2 leases that are signed by Mr. Williams, but no, there's no lease that was signed by both parties satisfying the statute of frauds.
She actually emailed the lease
right.
to William.
Hold on a second, ma'am.
Go ahead,
All right.
You-
Mr. Williams, you both of you raise your right hands for me, but I'm only going to be able to hear from one of you at a time, okay? And no jumping in. Do you solemnly, go ahead, raise your right hand. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes.
Okay. All right. So now, Mr. Williams, tell me what you wish for the court to know regarding this claim and your counterclaim.
Okay. First of all, we just set the record straight. We have an open-ended contract, lease agreement, and one was
That's what month to month means, but a month, no lease is open-ended, as in it can never end. A month to month contract means that instead of giving you 30 days notice that they want the contract to end, they have to give you 60 days notice. But it doesn't, once the notice is given, that's sufficient notice for a month to month contract. It doesn't, a month to month doesn't say that you can stay however long you want to.
well, this never was a month to month, is what I'm saying. This is
It was a rent.
it's a rent to own. This is a lease agreement, rent to own. Yeah, see, now, all that stuff is not true.
Okay.
So what we did, she sent the first lease to own, but we got the first one, and then I say no. Instead of paying it all, this $360 at once, can we break it down in 2 weeks? So she emailed me another one. That's why she didn't ever get her chance to sign it.
Okay.
But it's all, I sent everything to you. I think you got everything yesterday. If you can
Okay.
read through it.
Was her signature on the same lease as your signature?
Yeah. Yeah. Well, what happened? She emailed it. What happened? She sent it to me. I signed it, sent it back to her, and asked her, can she change it? So she got it and changed it, and then emailed it back to me.
Was her signature on what she emailed back to you?
It wasn't emailed back. No, it wasn't. It wasn't on it because her.
Okay, well then she didn't sign it, sir.
Well, she emailed it. What I'm saying is she emailed.
I don't care that she emailed it. So what you're talking about is the negotiation that takes place between parties. A contract is only valid. A contract, especially for rental, has to satisfy the statute of frauds. And so generally anything for over 12 months or over needs to be in writing, and both parties need to sign. If somebody's emailing a contract back and forth, well, they can do that during the negotiation process, but a contract does not meet the level of validity that is needed until such time as both parties agree, because then it says that both parties have a mutual meeting of the minds. If you have something that she sent back to you, but there's no signature on it, then there's no contract, not the type you're talking about.
Well, actually, there is a signed one. And now think about it. The very, very first one. She should have a copy of that. I think I saw it in court, the last court session we was in. So then we took that. We already, that's why I was putting a motion to dismiss this case, because we already been to court on the same issue, arista judicata. So we've been to court on.
So when you're in magistrate court and the decision in magistrate court is challenged, then it comes up what we call de novo. So it's a new hearing when it comes to state court. So it's not res judicata, it's a new hearing.
Right. So, but they dismissed that case, and then this was another time, is what I'm telling you.
Okay, if they dismissed that case on the grounds that she continued to accept money, once a dispossessory is filed, if the plaintiff accepts money after the date of filing, then it dismisses, it acts as a dismissal of the dispossessory. So they're not that, the magistrate court didn't say that you were right. What they said was the plaintiff who filed the dispossessory was wrong because she continued to accept money. I spent 4 years on magistrate court.
Right, I got
On
you.
these cases.
But if you see all the stuff that I sent in, all the documents, she didn't send me all the payments back. Some of it we got back in checks because we would Zelle it to her and she'll send it back. And we also got some of the checks. She sent it back in check forms, and then we mailed it.
Yeah,
and then
she
sent it
cashed the
back.
money orders and sent checks.
You know what I'm saying? So she received money. So and you should have all that in your file because I just dropped it off yesterday. So you should have all that, you know, from the rent, the lot rents sometime average from $550 to $750 a month. And I gave you a year of both that we paid. And some of it she sent back, some of it she did not. So she did receive rent.
Were there any payments made after this case was filed on June 21st of 2023?
Yes, she sent them back.
She sent them back. Yeah, she sent it back.
If she did, if she sent them back, then she didn't technically receive the payments.
Well, not all of them. Some of them she did.
How much did she not send back, sir?
If you look at, do you have the information I sent you, ma'am?
I do. But
Okay.
you have to make your case. I can look at the information you sent me, but it's not in the form of an affidavit. So you're giving sworn testimony that would be competent evidence of what you're alleging. So I can look at the papers, but if you know what it is, you need to walk me through it.
Okay. All right, this is the lease payment here. All right. I'll tell you the date. What was that? The one for okay. Oh, you say the one after, which date? After the 3rd, right? I mean, after March, right?
No. June 21st is when she filed the dispossessory. Any payments made after June 21st that you did not receive back or that she cashed, then that would invalidate this dispossessory.
Okay. Okay, October 23rd. October 23rd, and we got and you should have that.
Don't assume I have it. You have to walk me through it. So October 23rd, how much did you send?
This one was $360.
And you're claiming that you did not receive that back?
We got January, that's $360.
No. Listen to me, sir. We're still on October 23rd. So
October
you sent October 23rd. How did you send the money?
Hold on a second. That one's in there. Hold on. Just trying to get them all because I had them all together. Okay. Oh yeah, so it is right. October 23rd, $360.
Okay, when did you send it?
I sent it in October.
Okay, and when did you not get that back?
No, it's here. No, it's a money order. Didn't come back.
It did not come back?
Nope.
Okay, and okay. And you believe she cashed that money order? Have you opened all of the envelopes that she sent back to you?
Yes. Yeah, like I said, I got everything in order because we
okay.
She put it all
and
together.
then you said there was another payment made?
Let's see.
Yeah, she did.
I'm looking for November. Yeah. We got all the lease payment.
Okay, so you said there was another payment made?
Hold on a second, I'm trying.
And we've also been making payments on her behalf to La Costa, which this month was $800.
What's La Costa?
This is where the mobile home is being held. These payments have to be kept up or the mobile home, I believe, will be repossessed, or they, I'm not sure how that works because we've been paying. So
Also, December 23rd, there's another one.
23rd.
Yep, in
21st.
November.
we've been trying to contact Sylvia. She's blocked us on everything. She tried to make a side.
Okay. Hold on. Y'all got too many things going on at once. And so I got to
That's
squeeze
what-
my way through this because I hate lease purchases. They never go through. They never work. All these personal lease purchases where they say, well, I'm gonna rent to own, that never works. And I'm just gonna be blunt with you. Y'all have been in that mobile home for 10 years and you still don't own it.
Right.
You could have bought your own mobile home brand new off the lot. We want your business, Hutchinson Homes, Thompson, Georgia. I just remember that commercial from being a kid. But you could have brought your own mobile home by now, from paying all of this money on under a lease purchase. That's a fool's errand. And so y'all got a lot of stuff going on, and I just need to tease my way through it because right now the only valid action before me is a dispossessory. If it doesn't meet the requirements of a dispossessory, then it gets dismissed. If it does meet the requirements of a dispossessory, then we move forward. The other issue is these alternative payments y'all made to La Costa under a dispossessory. I don't know how that plays because if y'all made payments on her behalf that weren't a part of the agreement to rent the place, then I don't know what you're claiming those are.
It was a part of
was.
the agreement.
It's
We
in
have
the- it's in
to,
the
yeah, we have
contract.
to pay that to stay here.
Yeah.
We have to pay La Costa to stay here. We have to pay La Costa so that Sylvia's property is not taken from her because
Okay.
it's on someone else's property.
Right. So we've been making payments. Now I see it's 4 of them now. So
And she
January and
waited
February.
until-
Yeah.
Hold on. How much are the La Costa payments?
Anyway, between
The
it-
last
it
payment we
fluctuates.
made was $800. The water is included with this payment. The water and
Yeah, that's it.
yes, and trash
that's-
as well.
That's lot, sewer,
Yes,
trash,
yes,
and water.
yes.
Your Honor,
Okay.
I would only highlight that would be applicable if La Costa was trying to evict them. That's not the case here.
Because we've been paying it.
Right. If we hadn't paid it, a La Costa would try to evict Sylvia from this property as well. They would take her to court.
Okay.
It wouldn't be us.
Okay.
Now,
Okay. Hold on. This is the reason that you need written words, because was there a requirement for you in the lease agreement as you understood it to be, whether it was a verbal agreement between you and Ms. Simmons or a written agreement? Was there a requirement for you to pay what is amount to utilities? Because essentially if sewer, trash, water are in here, then you're essentially paying utilities, which the renter would pay.
yes, it's been going. It's saying that we're responsible to pay the lot rent. The lot rent goes up. It went up over the years. And
Okay, so then that's not anything that you were paying on her behalf. You're paying what is equivalent to if you were renting a house and you had to pay water, electricity, sewer, trash pickup, all of those things would inure to the renter, not the lessor.
But she has to pay to keep this property here. She has to pay. I believe it went up to like $500 a month.
Okay, ma'am, if it says in the lease as you understood it that you're required to pay those amounts, then she doesn't have to pay. That's what you have to pay. You're not saving her. You're staying in a place that she has placed on a particular lot. But if it says that these are payments that you have to make to a third party, it's the same as if you were making your water payments to the water company or your electricity payments to Georgia Power. It's the same.
But we've been paying. But we've been paying, and we've been paying on time. We had all the payments has been paid.
Okay, Mr. Williams, I don't doubt that. This is what I'm saying to you. There are several types of reasons that people can be dispossessed. First is failure to pay rent, which is a breach of the contract, which means that if you're in the property, there is a responsibility under Georgia law that the renter pays the rent, no matter whether there's problems with repairs. All of those are separate and can be used as an offset on the rent. But your responsibility primarily as the renter. If you occupy the space, you have to pay for the space. So your rent has to be paid and it has to be on time. If you fail to do that, that's a breach of contract and a dispossessory can go forward. The second reason is the either party can give notice to the other party that they want to walk away from the lease contract and go their separate ways. In this case, on a month-to-month rental, this is on the responsibility of the lessor, the person who owns the property. The landlord has to give 60 days notice that they want to end the lease and have you go your separate way. As long as they meet that requirement, then there's nothing that you can come back with unless they change that or unless they didn't give you 60 days notice. Your staying there after the 60 days is called holding over. That's the second reason you can ask for a dispossessory. If you are holding over on a property, after you have been given notice, I don't care if you're paying your rent on time or not, you could be the most stellar payer, but maybe they want to sell the property, or maybe they're moving to Florida and they don't have time to deal with it anymore. There's all kinds of reasons that they can give you notice that they no longer want you to be a tenant. As long as they give you 60 days, then you're staying beyond that 60 days is called holding over. And holding over is a reason to ask for a dispossessory.
Okay. So like I said, this is not a month to month. And she has a signed copy because she has the first one. So there is a signed copy because it was in the last courts with Judge Parker. So that there is. So what I'm saying, this is not a month to month. I know they're making you believe it is, but it's not. We've been making payment, and even during the pandemic and everything was tough, we were still making payment. And so
making payments. How much of the payment of $360 a month was going to buying this place as opposed to renting it?
Well, that's not what I'm talking about. I understand that. We know what.
Obviously, we're not speaking the same language. I don't care if you were making payments. If she says you have 60 days to leave, then if you stay beyond that point, it's holding over. You could be on time for every payment. And once she gives you 60 days notice that she wishes to end the contract of, then you have to leave. You keep saying making these payments gives you some kind of benefit beyond that.
No, but after we agreed, this is a contract. I mean, yeah, I could say
a contract means there's a mutuality, a meeting of the minds. You and Ms. Simmons need to be on the same page, which is why it should be in writing and signed by both. And I should be able to look at a copy with both your signatures on it. But a contract, whether oral or written, has to do with a mutuality of agreement. If it's not mutual, it's not a valid contract. You keep saying we were paying, but you're not telling me what you were paying for. Ms. Simmons says you were paying rent. And this looks like a rental agreement to me, because I'm not seeing anything in writing that's valid. But even if you were doing rent to own, you would have to tell me how much of this is going to buying the property versus how much is maintaining the property. It's like when you pay a mortgage, you pay over time, and the amount you pay, you'll have a percentage that goes to buying the property, principal, and then there's a percentage for interest. In your case, you're not telling me how much principal you have put into this property to buy it, but you keep telling me it's a lease and we're paying and we're paying.
$125 is going toward the property every month. I called them this morning. They said that it's $8 right now. She agreed for us to pay until the property is paid off. That's what the agreement was. And then once the pandemic hit, she saw everybody trying to sell. Then she tried to go up on the price.
Okay, an agreement for sale of land has to be in writing. Where's your written agreement?
She has the copy.
It's not before the court, sir. And if you, like every house I bought, I got the mortgage papers right now. Even if I've since sold the house, I still have the payment, the papers with my name on it, the company representative's name on it, my mortgage. I can give you my HUD. I can tell you everything where the money went for everywhere, for every house I bought.
Right.
There's paper. A sale of property has to have a paper agreement that you can look at and that you can present. That's why I say I hate these rent to own things, because there's no definition in the terms. You keep saying 125 was supposed to go to the house. Well, when you buy property, as you pay towards the principal on the property, the amount you pay to buy the house should increase. The amount you pay for interest should decrease. And so when I'm paying $360 a month, it should keep going up until most of that goes to buying the house, and the other part is the incidentals. But y'all are just paying the static $125 a month. This is under Georgia law, because you don't have a document that has both of you signed on it. You don't have terms that y'all agreed to. So the Georgia defaults to what it looks like. And what this looks like is a rental agreement, albeit a very long-term rental agreement, but you don't have any ownership interest in this property.
So her receiving 4 months of payment.
Now, you said she received October, November, December, and January. Is that correct?
Yeah.
Okay. She hasn't responded yet to tell me. You say you've opened everything and she hasn't sent it back, but you sent money orders in each of these cases.
Yeah, it was money order. Yeah, in those cases, yes, it was money orders. And then also, like I said, in the last court, when they dismissed it, there is a rental agreement in there. If we can get that in court, you guys have it.
Ms. Heath Fortson, can you pull up the agreement from before? It's not before me. If it was filed with the case, it should have come over.
Judge, I'm looking through the record now.
Okay, thank you. All right, so Mr. Connor, you've heard that the essentially the only thing that would invalidate the dispossessory is Mr. Williams' claim that they paid 4 payments of $360, one in October, one in November, one in December of 2023, and then one in January of 2024.
Yes, sir. Ms. Simmons, can you please raise your right hand for me, please? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. Has Mr. Williams made any payments to you?
Yes, he has.
Okay. And what did you do after he made those payments?
Your Honor, I received 3 payments from April to the present time. Immediately on the day I received them, I turned around that day or the next day, sent them back certified receipt, signed delivery on all of them. I have not received any of the payments from October to now, not one, Your Honor.
We have documentation to back that up. If Your Honor, let me just scan that in and submit it to the court.
That's fine, you can.
Okay.
All right, so Mr. Williams, Ms. Simmons is stating that she has not received any payments from April to present. She received payments from April to present, but she sent them back certified mail every time she received one. So is there any certified mail envelope that you have not opened?
No, I haven't, whatever she sent me.
Okay, you're muted, so I'm not hearing you.
Yeah.
Okay. So she said anything that she sent back to you would have been sent through certified mail.
I get, yeah, I'm assuming so.
Okay, and so Mr. Connor should have documentation of the certified receipt, return receipt.
Right. Yeah, I sent some certified stuff to them too, so they should have it as well.
Okay.
Have we been able to look up the agreement?
Okay, so sir, the agreement you keep telling me about, tell me what that is again and why it's so important.
Well, because it's a lease agreement that we put in place between 2 people, and
both of you signed it?
Yeah, correct.
When was this lease signed?
2016.
Okay.
Yeah, and I have, like I said, I had 2, so she emailed the other one.
Okay, but the 2016 lease agreement that you're talking about was signed by both of you?
Correct.
Okay, and so you've been on a month-to-month lease since that terminated?
No, it never was terminated.
Okay, so a lease is usually for a year. Commercial leases are usually for 5 years. A lease may not terminate, but it may renew automatically if neither side walks away from the lease. And so
Right.
you're saying that that lease just kept rolling over.
Yeah, it rolled over because of the way it was stated.
Okay, how was it stated? Read it to me, sir.
Okay. Lease payment. Let me see. Let me get my glasses. All right, let's say so. The date contract is signed by landlord and tenant, and loan is paid off. Or home is assumed by tenant with Vanderbilt mortgage. And that's like was just the extent of that. I mean, that's what we did back.
Hey, read that again for me.
Okay.
Your Honor, if I may, I submitted these documents to the court. I submitted them to Ms. Heath Fortson. I included them. That would have been, I just attached them for your reference in case you wanted to see them. They'd be plaintiff's exhibit P4.
Okay,
All right.
Ms. Heath
So
Fortson, can you pull that up for me?
all right. So what it says is date contract is signed by landlord and tenant, and loan is paid off, or home is assumed by tenant for Vanderbilt mortgage. And
Have you ever paid the mortgage, Vanderbilt mortgage?
yeah, well, I paid it directly to her, and she paid it
Okay,
every month. And even when the time was tough, we was paying it. So, like I said, I'm not understanding it.
sir, I'm not doubting that you paid an amount that you may have thought gave you some ownership interest. But what I'm telling you is under Georgia law, the way it appears under the law is that you paid rent. There's nothing that you've shown me that tells me you have some ownership interest, because what you're saying to me is she would have had to pay off the house completely. And once she's completed payment of the mortgage, then the house would be yours.
Yeah. And that's what we agreed on verbally and pretty much in writing.
Not pretty much, it has to be exact.
That's
But that the terms of that are indefinite, because so say she takes 1,000 years to pay off the mortgage, you're gonna keep paying $360 a month for 1,000 years?
no. Once it was paid off, because I'm on the mortgage to be able to find out what the payoff is. So I know what it is. This is why I told you today is $18,824.
All right, let me see that, Ms. Heath Fortson, share screen. Okay, so just so you know, Mr. Connor, Mr. Williams' counter argument, I'm not sure what the $100,000 counterclaim is due to. Why are you asking for $100,000, Mr. Williams?
Well, that was the rent, that was the mortgage, and the lot rent included in maintenance. I mean, I had a whole layout of that.
No, you lived there, so even if this was the rent to own, you lived there and benefited from living in the property, so that wouldn't be something that would be a valid counterclaim.
Okay. All right. Can I read this to you? The purchase?
It's coming up, sir.
And Judge, this is the lease to purchase that's within the record, and I believe the same lease to purchase plaintiff's attorney sent over this morning.
Okay. Hold on a second, go back down.
Would it say purchase?
Hold on, sir. It says lease to purchase binding contract, and I'm sure one of you typed this up because it is not a good contract.
That's good. He did.
Okay, so the lease term is the date the contract is signed by landlord and tenant, that would be the beginning, and loan is paid off. So the loan hasn't been paid off, is my understanding, has it?
No, $18,824.
Okay, so it says that go back down, Ms. Heath Fortson, because I was still reading that part. Okay, so the lease term is indefinite because, go down a little bit more. Okay, date contract is signed by landlord and tenant. That's known because you can tell me, according to this, y'all signed it on a particular date. And right. Loan is paid off. Well, the loan is not paid off. So that term is not met at all. or home is assumed by tenant with Vanderbilt mortgage. Did you assume the home with Vanderbilt mortgage?
No, I didn't. I tried,
Okay.
but.
All
then
right,
on-
wait, no. So right there, this provision of the contract is invalid.
Mhm.
Let's go down. Lease payment. Tenant agrees to pay to landlord $360 each month for rent due on the for rent. You see that term right there? For rent. Due on the first of each month. Payments will be made. They're going directly to Ms. Simmons, not to Vanderbilt Mortgage. And it's paid, you agreed per this document that you're making $360 a month for rent payments. You see what I'm saying?
Right, so,
Language matters language matters in legal contracts.
okay,
I am
gotcha.
bound by you telling me, look at this contract. So I'm bound by what it says. Now we've
Right.
already figured out that the lease term provision, this part of the contract is invalid because it doesn't make any sense. This
Mhm.
part hasn't happened, even though it's required to begin the lease term, and the home has not been assumed by Vanderbilt Mortgage. So that hasn't happened either. So let's go down to payments. You're agreeing to pay rent. That's what it says. Not pay to purchase, not pay for lease to own. It says rent right there. That's what you agreed to. Late charges. Tenant agrees to pay a late charge of $50 for rent past due 15 days, $100 late for rent past due 25 days for rent. Once again, there's that word, past due 25 days for due date. This is the problem that I find that a lot of lay people have. Y'all think you can come up with a contract because everybody can write, but people don't understand that words have meaning under the law. It is what you agreed to. And so if you put on here, you're agreeing to pay rent, that's what you agreed to. I don't care what the heading says, because generally headings are not binding. What is in the paragraphs is what matters when you're looking at the four corners of a contract. When you tell me, look at the contract, it's lease to purchase. But when it says repeatedly rent, 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 that's what I have to go by.
Your Honor, I would also just say that this contract was not signed by my client either.
Yeah, if
Okay,
you,
so Mr. Williams, you misled me. You said that it was signed.
I said it was, if you go to the history with Judge Parker, that's dismissed the case the last time, there was one in there.
Okay,
There was-
well, you should still have that.
No, I didn't get a copy of it. I saw it when she brought it
Okay,
by.
Mr.
Okay.
Williams, how is it you have a contract as crucial as buying a house and you don't even have a copy of it?
Because what happened, like I said, when I sent it back to her to change it from paying $360 a month to paying every 2 weeks. That's when she emailed it back over.
Okay,
me.
and when she emailed it back over, you should have been able to print out a signed copy. Did she
Yeah,
sign it?
No, she didn't sign that one, but she
Okay,
signed
well
it.
then, sir,
Sir,
sir, listen to me. When you said, I can't pay every a month, let's break our payments up into every 2 weeks. That's
Right.
called a novation. So
Mhm.
you all are negotiating this contract, but you
Right.
put in a significant change and you send it back to her and you say, I need to change a provision of the contract. So, okay, we don't have a meeting of the minds. She's saying pay per month. You're saying pay every 2 weeks. When it goes back to her for the novation, which is a legal word meaning you're changing the terms of the contract. When she sends it back to you, if it is not signed, she has not agreed. So y'all don't have a contract in writing.
Your Honor, I would also, if I can ask my client a few questions, just I feel like it'll kind of streamline them and kind of go to the defendant's credibility just overall, Your Honor.
All right, so Mr. Williams, I've done all I can do. Mr. Connor has some questions for you.
Oh, no, I just have some questions. One last rebuttal for my client going to a circumstance that occurred. Did the defendant ever try to, and it might remind you that you're under oath as well. Did the defendant ever try to induce you into perpetrating a fraud?
Yes, it did.
Okay. Tell the court a little bit about what happened.
Your Honor, everything Willie and I did was via text. He sent me a real.
Okay, I can't. Mr.
Okay.
Connor, you're coming in a lot better than she is, so you may,
Okay.
you may need to switch.
I just didn't know if you want to hear directly from her. Your
No,
Honor, but-
no, what I'm saying is I can't understand what she's saying.
Okay.
She,
Yes.
yeah, yeah.
I apologize, Your Honor.
No, that's fine. Just talk to me.
Yes,
hear you
I
now.
received a text from Mr. Williams asking me to, that he was working with a rental assistance program. He asked me to write him a letter saying that his mortgage or his rent was $1,000 a month and that he was 15 months behind. And that they would pay me $15,000 directly that he would put towards purchasing this home. I write back to
Okay,
him.
so hold on, Miss Simmons, you were frozen for a minute. Okay, you said you received a text message and he was working with a rental assistance company. Go from there.
And he wanted me to write a letter saying that his rent was $1,000 a month and that he was 15 months behind. I wrote him back and said it is fraud because his rental payment is $360 a month, and he is definitely never been 15 months behind. They were going to pay me the $15,000 to put towards the loan. When I told him it was fraud, he started backpedaling in the next text saying it's because of, I told the court that he was behind, which we had not even been to court. And the only thing I put in the last dispossessory was he failed to pay in a timely manner.
Your Honor, I submitted that to Keith Hortson, I apologize, and that is marked as Plaintiff's Exhibit P3, and I moved to tender that to the court at this point.
All right, Mr. Williams, any
Okay.
objection to him showing me that?
I mean, he could show you because I have it too. I think I put it in there too. It was only because he said I was behind and I wanted her to prove it in writing, on text message that I wasn't behind. I never did any of that
Okay.
stuff.
I
It was
think
only-
we're going far afield. So let me just listen to me
Yeah.
carefully, Mr. Williams. The contract that you wanted me to look at is not a contract. Even if I considered it a contract of anything that y'all are talking about, you keep saying rent, 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 and you're agreeing to rent, rent, rent all through the contract. So what you have is a contract to lease, not to purchase. You don't even have a copy of her signing the contract. So there's no mutuality of contract, and one-sided contracts are invalid.
But if it's
The contract, listen to me,
Okay.
because
Okay.
I did this in magistrate for 4 years. I've been on this court for 8 years. I wrote the training manual for new judges for state court on dispossessory. So I pretty much know what I'm talking about. When we get into people individually trying to come up with their own legal documents, but they don't have legal training, that's where you mess up. And in this case, y'all messed up. So even though y'all might have thought you were doing something, you did something else. In this
Right.
case, Mr. Williams, you have had a long-term month-to-month lease for the property. Ms. Simmons has given you 60 days to leave the property. You're now doing what is called holding over onto the property, because she's given you legal notice that she wants the lease to end. And so at this time, there's nothing that you've told me that supports your theory that A, you need $100,000, your counterclaim is denied, and B, that you need to remain in the property.
Okay, so you're saying her accepting the money that we've given her,
Sir,
that Go ahead.
you allege that you sent her the money. She has said that she didn't receive it. Do
well,
you have anything where she cashed it that you can show me?
I think I gave you the stubs. I gave you got all the
Okay,
stuff.
sir, if you purchase a money order, anybody can tear off the stubs and hand them to me. Do you have the negotiated money order copies where they actually were put into an account and used as money?
No, I would have to get her bank account for that. I mean, how
You
would
have
I?
a case pending. You could have subpoenaed those records.
Well, I didn't know that. Like I said, all I know is that we've been paying on time and we've been taking care of our
Okay,
business.
and like I said, paying on time is not why she wants you out of the property.
What is the reason she want me out of the property?
Holding over the lease, she has decided that she wants the lease to end. She's given you statutory notice of 60 days. Anytime past that you remain in the property, you're holding over.
Right.
Rental payments and late rental payments or missing rental payments is not the only reason people can ask for possession.
Even after we agreed, did we ever find, so we still hadn't found that agreement from Judge
Sir,
Parker?
I don't know what you're talking about, but Judge Parker dismissed this. I don't know what agreement you're talking about, but you haven't been able to give me anything you signed and she signed at the same time.
Yeah, well, and are we able, I have a family here, ma'am, so are we able to get with the judge and go ahead and subpoena that?
I am the judge. This is your court date. You should have subpoenaed it up before this. You've had 2 court dates. So I'm not sure how we made it to 2 court dates before 2 separate judges, and you still didn't know that you have to present everything you have. Number one, I get that you have a family. Dispossessory is one of the hardest things I do. But generally, when a situation like this happens, let me just tell you, over the course of the 12 years that I've been doing this and all of the dispossessories I've done, do you know the last time I found a valid lease purchase agreement? Never. I've never found one, because it is always the parties who are trying to draft it, and no lawyer has ever drafted a lease purchase agreement that I've seen. It's always parties saying, well, let's get together and think through how we're going to do this, and it's always wrong.
Well, I have put something in there. I put a motion for us to do that, but they denied it. So, I mean.
Okay, so
Yep.
the court is going to grant possession of the property to Miss Simmons. Payment of the amount of $3,960 in rent, because you're under Georgia law, as long as you're in possession of the property, you have a responsibility to pay. And then $3,000 in attorney's fees.
So why am I paying that and she already have the money?
Sir, you haven't proven to me she has anything that you have paid since June 21st of 2023. You say you have stubs. I have stubs. I can buy a money order tomorrow and have a stub, and the money order still sitting in my car or in my hand.
Right.
You have failed to prove that evidence. So, Mr. Williams, now this is the part where I am constrained by law. I can only give you 7 days to move. I can give you 7 days before the writ is executed. If Ms. Simmons is willing to give you more time to move, she can do that. I don't know if she's willing to, but I can only give you 7 days. And so when the order goes out, you'll have 7 days from the date of my order to vacate the premises, or a writ, or they can do a dispossessory through the sheriff's office.
Thank you, Your
Yeah.
Honor.
I mean, unless you say we can continue the case. I mean, what else can I say?
There's nothing else that I know of, sir, but I'm not your attorney. But Mr. Williams, I caution you, and I hate to see this happen, but it happens repeatedly to people who think they're doing something, and nobody ever says, well, let me take a few minutes and maybe have somebody who's a lawyer look at it, or let me figure out if this is exactly what I'm doing. Because let me tell you, words matter in the law. That's how we live or die. And especially in a contract, every word, every comma, there have been commas that have cost companies millions of dollars because they were put in the wrong place in a contract. And so if something as little as a comma can cost you millions of dollars, every word that you put in a contract matters, which is why lawyers get paid, because we know what those words mean. And so when you're trying to come up with something and the intent is unclear, then have a professional draft it.
Yep.
Okay. All right, so the dispossessory is granted as long as well as the judgment.
Would you like me to draft the order, Judge, or
Yes,
will your?
please.
Okay.
Just draft it.
All
All right,
right, today, Judge.
All right, Mr. Williams, you'll get a copy of it from the court.
Thank you, Your Honor. May we be
Thank you.
excused?
You may.
All right, thank you, Your Honor.